Thank you, Judge. We have filed a notice of hearing at Jacksonville and previously been notified.
Okay. All right, let's start in this commercial with yours.
Thank you, Judge. I'm just going to go over procedurally all the motions that are filed by number and state what they are.
Great.
The ones that are withdrawn, the ones that are attention to the state is consenting to, and the ones that are withdrawn.
Great. And let me call on the state each time that they're through. All right. I'll get that. Thank you.
Motion number one is a motion to dismiss the indictment to the constitutional provision and rate that is provided by the defense. Motion number two is a motion for removal of 2 years prior to felony. We are also withdrawing that.
All right. We make notes on that.
Number three is a motion for complete information and transfer of all pretrial and trial proceedings. I believe that is being considered to by the state.
All right. Am I following you, please?
Yes, sir.
All right. Is that correct?
That's correct. You don't need under the rules, we're required to that you basically out there.
All right. Hey, you need for thank you.
Number four is a motion for order providing access to physical evidence to the drawing application. Number five is the demand for trial.
Yeah.
Motion six is a motion for disclosure of appeals and witnesses. State already to comply with the law and act, so we do not get any other.
You can follow on this.
Just as today's day, there is no building that's in the case that we need to be disclosed in the rules. All it allows is that company should be public at current trial, this is there are no additional.
You acknowledge your department, the real system.
Absolutely.
It is now.
Yes. Judge, number seven is a motion to reserve the right to file additional motions. We've already dealt with that.
Well, I want to be fair to both sides. I think the person who gets trial, try to be reasonable, try to give us all notice of them as they come up, so we can fairly hash them out.
Thank you, Judge. Number eight, motion to reserve the use of the word murder. That we will have a hearing on this morning.
All right.
We are prepared to go forward with that.
I'm sorry.
Thank you, parents, for your review.
I'll go forward on that. I'll be the first here. That's what I'm thank you.
And Judge, just to proceed on the hearings, I'll let you know that I'm arguing on this arguing. Is it possible that we can argue each motion individually, or we can go for argument and say about it, and then we have our final word on our motion, and then we move on to the next
I
one?
think that would be my preference.
Number nine is a motion for approval requiring the district attorney to respond in writing to each motion which is testified as stated in the writing. Number 10, 11, and 12 all deal with clothing and security measures. I believe all are already on the call.
I'm sorry, you're talking about 10, 11, 12.
No, sir, and this has been included with us in our
Thank you.
Number 13 is a motion for in-camera inspection of the files of all police witnesses we are withdrawing that motion. Number 14 is a motion to conduct a closed evidentiary hearing on the closure of pretrial proceedings we are withdrawing that motion. Number 15 is a motion for an order appointed impartial witness monitor we are withdrawing that motion. Number 16 is a motion to disqualify all potential jurors who knew or were acquainted with the families with the state and agree with that motion right at this point.
That's correct, but I think that's something that we take that at this time when we do
Number 17 is a motion for individual writer of first frustration of during writer. I believe that's the same position. That is something that will be involved in many questions. Not right. Number 18 is a motion to protect the jury from exposure to victims, family, or friends. We are withdrawing that motion. Number That motion and number 21, which is the 300 challenges, and the 22, for the strikes, silent strikes. I believe that all of those are common practice in this jurisdiction.
It is, all of those are there outside the knowledge of the jury and silence.
Wonderful.
Or
Thank you.
handling, back and forth. Anything further comes up about that? Yes, Ms.
Sorry, I just want to make sure we're clear, because it technically says outside the presence of the jury. Usually we have the jury in panel and seated, but we pass the list and have silent
And
strikes.
silence, that's right.
That's perfect. That's wonderful.
Great, thank you.
Thank you. Number 23 is a motion to extend the time for closing arguments. I had indicated that we did not at this time know if we needed that or not. I know the state said that they would consent to that, so I think that's something that we can reserve
Yeah,
to
let's
discuss
reserve.
during trial.
I agree, let's reserve on that. You know, I noticed the first line of that says, right now, the individual faces a potential sentence of life imprisonment without parole.
Right.
We all agree to that?
No, sir.
I do not.
We agree as well. We did not
The
follow
only
that.
sentence upon conviction would be life with the possibility of parole. Is that your?
That's our understanding, Judge. We did not file that motion. And since there's been no notice filed of aggravation of punishment, we believe that a conviction on counts 1, 2, or 3, any of the murder counts, would be a mandatory life with parole sentence.
As it sits right now. Right.
Yes.
Okay.
Great, Judge.
Y'all
Even
do
the
that,
date
Ms.
of the
Hart.
crime
Thank you.
occurred.
All right, 24 is next on my list.
That is a special demurrer. We will require a hearing on that. We're ready to proceed. I will be arguing that.
That's number 24. All right, now the issues addressed, there were 2 demurrers filed. This one addresses the
Judge, the one.
sufficiency of the indictment itself.
Yes, Judge.
To
24.
adequately inform Mr. Duke of his,
Yes.
using his hand. Thank you.
Yes, Judge.
All right.
That's number 24, and I'll be arguing that. Number 25 is the other demurrer, the plea and bar based on the statute of limitations, which we are withdrawing.
Mr. Young. Thank you.
Number 26 is a motion to suppress Mr. Duke's statement and for a pretrial Jackson Denner hearing. We had asked that that be heard at a later date. If the court is inclined to hear that today, we would just like to renew our request for that to be heard at a later date.
We addressed that last week. Ms. Hart, I heard that.
Judge, as we discussed in the phone conference, we would object to being continued given it's been scheduled for some time. We're prepared to go forward, and I'll be arguing that with the state.
All right, we'll go forward with that today.
And Judge, we would be withdrawing the Jackson Denner hearing and not challenging the voluntariness of the statement then based on that ruling.
Okay. Ms. Hart?
I don't know if the court wants me to go into details right now or wait till we're done, but there are multiple levels to the statement as far as pre-Miranda, post-Miranda. Some are done at the police department, some are done somewhere else. Given that, I think we need to address specifically what we're talking about that's admissible. But beyond that, Judge, I think we can take that up after we finish going through this list.
We'll do that. All right, next is 27, is that right?
27, yes, Judge, it was just, that was a duplicate of another motion asking for more time to file motions, which the judge has already, which the court has already indicated.
Right, we're going to be reasonable about that. Go ahead.
Thank you, Judge. Number 28 is a motion to transfer venue. It's my understanding the state is consenting to transferring venue, and we have the task now of trying to determine where.
Ms. Hart,
Judge, while we don't necessarily agree with some of the statements that were made in the motion, we are agreeing to transfer venue. And again, as Ms. Merchant indicated, that we would be looking to see if there's a place that would be adequate for the court's
we
review.
believe absent your objection that is there no further inquiry necessary by the court?
Mr. Powell.
No, you have discretion, you don't have to accept the power.
Right.
That's a matter that's entirely within your discretion.
That's right. Let's proceed with that at this time. 29.
Number 29 is a motion, defendant's motion for an investigator, or funds to hire an investigator, and we're prepared to proceed on that. To my understanding, the state is objecting to that, and I will be arguing that.
Okay. Ms. Hart, is that on your list for you today?
Yes, sir. Mr. Bowden will be arguing that on behalf of the state, and we would like to be heard on issue.
Pardon me?
We would like to be heard on that
Right.
issue.
Thank you. All right, next. 30.
30 is a motion for an order requiring that we receive a jury list at least 10 days prior to trial. It's my understanding that is consented to as well.
Sure, as soon as we have it, as soon as we get it, that's for sure.
Thank you, Judge. Number 31 is a motion to allow the defendant's family and friends to be present at trial or for a show cause hearing as to why they should be sequestered. The state has indicated that they have not put them on the witness list, but that is ongoing, and so they don't believe it's right. We agree with that. We don't have any problem hearing that immediately prior to trial once discovery has closed.
That'll be fine. Thank you. 31 is deferred.
32 is a motion requesting that the court, the judge, not read the indictment to the jury prior to opening statements. I believe we need a hearing on that. Mr. Merchant will be arguing that.
Thank you. 32 will be on the list today.
33 is the defendant's motion to make a full and fair opening closing argument and restrict the state's final argument to rebuttal. I believe we need a hearing on that, and I am prepared to argue that today.
Okay. Anything further, Ms. Hart?
Next, sir.
And then Ms. Purchase? Okay. We'll go forward then with the defense motion number 9. I believe you said that's yours, Ms. Marshall?
It is, Judge. Thank you.
Okay.
Yes.
All right, when the order requiring, no, that was wrong. What did I get? What's your first motion?
I'm so sorry. It's number 8. Yes, number 8. It's a motion to restrict the use of the word murder.
Okay, I'll hear from you next.
Thank you, Judge. Judge, we would ask for an opportunity to argue these motions and then to offer rebuttal after the state argues. The state has not responded in writing to any of these motions, which I know they're not required to do.
I'm going to give the move in. You can make your argument, then I'll hear from the other side, and then you get close.
Thank you, Judge. Judge, the term murder is a legal term. It's something that the state is required to prove in this criminal prosecution beyond a reasonable doubt. By allowing witnesses or the DA prior to closing argument to use this term murder, you're essentially allowing them to issue their opinion on whether or not a murder actually did occur. And that's one of the questions for a jury to determine in this case. It's entirely appropriate for the state to argue that in closing once the evidence is closed, but it's not appropriate for witnesses to state their opinion on whether or not a murder happened, whether or not a homicide actually occurred here. And it's not appropriate for the state, prior to closing, to argue their opinion that a murder or homicide actually occurred here. This is a legal term. It's a legal conclusion on the ultimate issue. It's subject to objection during trial, so if the witnesses or the state were to use this term during trial, we would be in a position to continue to object. So we're asking for a pretrial ruling on it. Judge, the law on this, there's been some case law on burglaries, for example, Wells versus State and Copeland versus State. Wells versus State is 151 Georgia App 416. It's a 1979 opinion. It says a statement by a victim that his house had been burglarized was found to be error as an improper expression of a legal conclusion by a witness. So that was in regards to the legal term of burglary. He was making a conclusion.
151 at what?
151 Georgia App 416. And it's a 1979 case.
The other one, Copeland?
The other one is Copeland versus State Judge, and that's at 160 Georgia App 786. That's a 1982 case.
Those are in your motion?
Yes, Judge. I believe they're in my motion. If not, I can supply those to the court.
Well, I got it.
The one that's in the motion is the primary one, the seminal case on this. It's Marks. Marks was a rape case, and Marks is the one that is cited in our motion. It's at 237 Georgia 277.
I see that. Okay.
That's really the seminal case. I included the burglary for oral argument today to give the court some context outside of rape. That burglary also has been decided. But Marks is really the seminal case on this issue. In that case, the alleged victim was using the term rape, and the state was using the term rape. And the court in that case said that that was a legal conclusion, and it was improper to use the term rape.
And that was from a witness on the stand, is that what you're telling me?
It was, Judge.
On both instances, the burglary and the rape case?
Yes, it was. But the court did talk about how it was improper for a district attorney to comment on that. It would be stating an opinion prior to closing argument. There's another case that the language in Marks says if a witness uses the term, it implies a legal conclusion on the ultimate issue, and that is subject to an objection. The determination of whether or not a crime has been committed is solely in the purview of the jury on an issue of fact. And something like murder, rape, those are issues of fact. Additionally, Judge, this is a jury issue, whether the jury can determine whether or not a homicide occurred, whether or not a murder occurred. It's just not appropriate prior to the state's closing argument. And we would just ask what the harm is to the state in limiting the use of this term prior to closing arguments. The only benefit to the state would be to prejudice the jurors and to have this term used throughout a trial in front of the jury so they continually hear the word murder, murder, murder. And they're more likely to believe, not depending on the evidence, but believe that this occurred because they hear murder over and over and over again before they've even heard the conclusion of the evidence. So it's our argument that it would be harmful to the defense. It would definitely be harmful because they're allowed to state a legal conclusion that is a decision for the juror to make. It's just like saying the whole time, guilty, guilty, guilty. I think he's guilty. I think he's guilty. It's the same prejudice as saying that. I think a murder happened. I think a murder happened. A murder happened. Hearing that over and over again makes a jury psychologically, makes them accept that, more so being the truth.
Well, of course, I'll tell the jury that they're to decide the case on the evidence. The evidence comes from the witness standing the exhibits. If the witnesses are prohibited, does that satisfy your request to that?
To a certain extent, if the witnesses are prohibited and the state is prohibited from asking the witnesses, and in their questions, if they ask the witnesses, did you investigate this murder? Let's just use that as an example. If the state is allowed to say, did you investigate this murder? The state is therefore telling the jury during the evidentiary portion that they believe a murder occurred. And they can argue that in closing, but they cannot state their opinion during the case in chief. Okay. And so they're stating their opinion that a murder occurred. And we think it's prejudicial to the defense and that there will be no harm in limiting the use of this word. They can prove what they believe they can prove without using a legal conclusory word. And so we would just ask that you restrict the use of this word.
All right, thank you, Ms. Mercer.
Thank you.
Mr. Brady, I'll hear from you on this case.
Got me out there.
All right, this is Stanley versus the state. And these are all Georgia cases?
They are, Your Honor. Your Honor, the OCGA 16501, of course, establishes malice murder and as well as felony murder that the state is required to prove. That's what's charged in the indictment. That's what the judge calls it. That's what the state calls it. That's what we have the burden of proof beyond a reasonable doubt to prove in this case that Ryan Duke murdered Tara Grinstead. That's our burden that we are to carry. To prohibit our use of the term murder also prohibits us from being able to adequately represent the interest of the victim in this case, and for restricting any use of that term by witnessing would also be that way. What Ms. Martin didn't address are two cases that are actually murder cases in which this issue was before the court, both Georgia Supreme Court cases, not Court of Appeals cases. Stanley versus the state is the most recent case at 300 Georgia 587 2017 case in which this issue was that they had filed a motion in limine for trial, as we have here, to limit the word of murder. The judge did not limit that in that case. However, during the trial, if the word was used inappropriately, the defense could object, and then the judge could instruct at that time that they are the arbiters, just as the instruction the court just provided earlier to Ms. Martin as an exercise, that they would be the ones to determine what that was if the word was used inappropriately or inartfully in those terms. In that case, in Stanley, the word murder was used 12 times. The court found that that was not a problem in that case, did not reverse on any of those grounds. It cited another case called Laney versus the state at 271 Georgia 194, a 1999 case in which the court said that the use of the term murder within murder trials by the state and its witnesses are not problems as well. Also citing James versus state at 270 Georgia 675, a 1999 case. Cited Lane, and it also cites Stensky. Stensky cites the James case. But Stinsky is also a death penalty case, in which it's at 286 Georgia 839, a 2010 case. The trial court denied the motion to restrict the use of the word murder at the trial, and this, of course, was held not to be error, and it cites the Laney case and the James statement in those cases. So there is no error by the court for restricting this use. We ask that it not be restricted. This is what we're required to prove. The case cited by the defense in their motion, Malice V State, is a rape case, and they cite a burglary case. They're not citing murder cases, which I've cited for you here today. Those cases, the rape cases with Malice, went to the ultimate issue because the defense in the case was consent. In our case, it's not analogous. There's nobody consenting to a murder. So again, the use of the term rape, the issue was for the jury to decide whether the woman was raped or not, or whether she consented to the sexual contact. Therefore, the ultimate conclusion was left to the jury of whether or not she was raped. So Malice is not applicable here. It is not the same factual scenario. It's not on all fours with our case. Other cases that Malice is cited by, in other cases where rape was not appropriately used, the judge restricted the term. It was also consent-based offenses in that regard for using that term rape. So I don't think those are applicable here for a murder case in which we have two murder cases that are tried, one being a death penalty case in which the term murder is allowed to be used and is not found to be erred by the court, and we certainly ask that the court deny this motion.
It's interesting, let me ask you a couple of questions, Mr. Reed.
Sure.
Your Stanley case, they have enumerated in here the 12 questions that apparently where the state question included the word murder.
Yes, Ron.
And so at some point, it appears the trial judge instructed the state to refrain, here's some language, after the first objection, the trial court admonished the prosecutor to refrain from using the word too much.
Right. Still did not restrict it altogether.
Did not bar the prosecutor's use of the word.
Correct.
So what's the test?
Well, there is not a test. There's not a test given. What they said in the analysis here is that these 12 questions, most of those are referred to by the lead investigator in the case, referring to it as the murder. Because of that, they didn't find any prejudice. They didn't find any problem with the court that the court said too much or anything else. There was no reason given, no test given, just that the use of the term murder. They also cite back to, like you said, Laney, which Laney basically says that the use of the term murder is fine and is not restricted, carte blanche, and there was no limitations given.
Right. Let's see. Laney is.
I don't have Laney before you.
I see it. It's a 99 case. Trial court was not obligated to bar the prosecution from using the word murder as a punishment. Well, Steve Laney. Trial court did not err in permitting the prosecutor to use the word murder instead of homicide. Prosecutor's use of the word murder in his 12 queries to witnesses did not require those witnesses to opine on the ultimate issue in the case, whether the appellant was guilty or not guilty of murder.
Now that would be what would be improper, is we ask the witness to opine whether or not that would be the issue, and that would be an ultimate issue for a juror to decide. But it doesn't restrict the use of the word murder by the prosecution, nor does it restrict it anywhere else.
Your appellant has failed to show that the term murder was used in an inappropriate way to influence the jury's seat Inman versus State. In order for it to be reversible error, there must be harm as well as error. Are y'all familiar with Inman by any chance in this reference in this Stanley case?
I'm not familiar with Inman.
Okay. Anything further?
There you go.
Good. Thank you. All right, you get the last sentence, Mark.
There's a couple things I wanted to point out. First of all, the state said that they needed to be able to use this term in order to represent the victim in this case. Their job is not to represent the victim. Their job is to represent the state, and their job is to seek justice. And that's what we're trying to do here. We're trying to have a fair trial where the result is justice, and it's a fair trial based on the truth, not based on prejudicial use of words that are designed to prejudice the defense throughout the trial prior to the jury's determination. Judge, the case that they cited, Stanley versus State, in that case there was a pretrial motion in limine where the judge granted it in part denied it in part, and basically said that the judge was not going to limit them to not use it at all, but really wanted it severely limited. The prosecution is severely limited.
That's what I get out of the reading of this.
Right.
But I'm trying to decide if there's anywhere in this case that y'all have some suspicion as to what is overdoing it.
Right. I understand, definitely. And in that case, as many times trial courts do, they said, to the defense, just go ahead and object when it happens,
right,
and we'll see how it goes. And so the defense was put in the position where first time they had to object, second time they objected. They missed a couple objections. It was getting to be too much, and so the court talked to them about it and told the state to limit their use. In that case, it said that the record shows that they used the word 12 times, murder 12 times when examining witnesses. Most of the time, it was during leading questions for the lead investigator, which is what my example was earlier. The appellant in that case objected 3 times. The trial court admonished the prosecutor, but did not bar the use of the word. The trial court sustained the objections. So the trial court granted the objections that the defendant was posing, objecting to the use of this term.
Except looks like one question.
Well,
Two questions.
And it's confusing. It looks like the defense lawyer didn't pop up every single time.
That's right.
So
But when he did, it looks like they overruled it.
Some
No,
of
they
it.
sustained the objection when they popped up, as you said.
Right. So the court did grant the objection to limit this term when the defense lawyer objected. And then finally, the third time that the lawyer objected and it was sustained, the court had to give a limiting instruction to the jury. That's what we want to avoid here. And this, you've got to understand, the Stanley case is after the fact. So everything's being reviewed for plain error in this case. And we all know that our appellate courts bend over backwards to preserve a decision in the case. So they're going to do everything they can to not find plain error. What we're trying to do is we're trying to make the determination pre-trial. We are trying to make this determination so that there is not a prejudicial effect during the trial. And in this case, they found there wasn't plain error because the judge did a jury instruction, a limiting charge. Well, that's not, we're asking to avoid all of this error. We're asking to avoid the error that happened in the Stanley case. And in regards to the Marks case, in that case, the state argued that the issue was consent because it was a rape case. The issue here is whether or not a homicide did occur. So we do have an issue here of whether or not it happened. It's not an issue of whether or not there was consent. It's an issue of whether or not it occurred. And Judge, I know that you had asked about a test, but there really isn't a test other than prejudice to the defense, whether or not it's going to prejudice the defense. And all of these cases that the state cites are after the fact cases where either the defense lawyer didn't object or there wasn't found to be substantial harm based on the overwhelming evidence in those cases. What we're asking for is a pretrial ruling that the state is limited from using this term.
I'm interested to see if there's any language in this in case I can address the further that we did.
And I asked Mr. Archer to pull that up as well, so I'm hoping he did. Do you have the site, Judge, of that piece?
Yeah, 281, 67. Sorry.
Yeah, 281. It's in the standings.
Oh, in the Stanley case.
Cited in the standings. 281, Georgia 67, 2006.
My reading of that, just very quickly, is simply that in a death penalty case, where it just basically says, as it quotes it, in order to have reversible error, there must be harm as well as error. And so basically, they're just saying there is no harm if there's no harm that's even as well. And it's just like a death penalty case where the harm is error.
I don't even see where there was a...
There's no issue about murder.
Right, okay. Y'all, did you scan that real quick? I don't think it addresses any point that we're talking about now. I think it's just for that, for the board. Okay. All right, I want to read your cases thoroughly, and I'll have you more about the day after we adjourn these hearings, whether that's tomorrow or the next day. All right, that was, what's our next motion to be?
Just next motion on this discussion here, I do have 2 witnesses here on the Jackson Dinner issue. If the court wouldn't mind us addressing that first, so I could get them
Sure.
Just so we can put everything on the record with that.
Yeah.
Judge, as it relates to the Jackson demo that we had requested, and then also the motion to suppress the statements that was requested by defense counsel, there are, as the court, I believe, is aware at this point, there are the statement that took place the day of the defendant's arrest. When the defendant initially came down there voluntarily, he was not under arrest. And Miranda
Down there.
to the police department, sorry.
Police department.
And
Still a police department?
it's still a police department. He was not read Miranda at the beginning of the interview. About 5 minutes into the interview, after there are some inculpatory statements made, the agent stops and then reads Miranda to him and continues with the interview, and it goes on about another hour and a half after that. Just want to make sure that when defense counsel is saying that she's drawing her objection as to the voluntariness of the statement, that we are including both the pre-Miranda and the post-Miranda statements in that.
Ms. Merchant.
We are.
Okay.
Or withdrawing our objection. Would you want to allow me to prepare a board on that case?
That'd be fine.
And just to be clear, as in addition to the voluntariness, they're indicating that there was no Miranda violation, and also that there was no hope of benefit or remote injury, fear of remote injury. Yes, Judge.
And all issues,
Jackson dental issues.
all Jackson Dental.
Yes, correct.
Okay, if you'll prepare that order, please.
Yes, sir, thank you.
All right. The next, what's next on your list? 24?
Would be a special demurrer.
Okay. I'll hear from you on that. Is that yours as well, Ms.
That's
Merchant?
fine. Thank you, Judge.
Okay.
Judge, the special demurrer is where we are arguing that certain counts of the indictment, specifically counts 1, 2, and 4, are devoid of the required legal and factual specificity. And the law is OCGA 17-7-54. It requires that every indictment state the offense in terms and language of this code, or so plainly that the nature of the offense charged may easily be understood to the jury. And we're really focusing on that second part, that that it's so plainly that the nature of the offense charged may be easily understood. When a crime can be committed in more than one way, the particular manner in which the crime was committed must be specifically set forth in the indictment. And that's based on the United States jurisprudence, Russell versus United States, which was the original seminal case. But I'm going to cite some Georgia law, and I've got copies for the court in the state. Russell required that to be legally valid, an indictment must, 1, sufficiently apprise the defendant of what he must be prepared to meet, and 2, identify the offense clearly so that he is tried for the same charge for which he was brought before the grand jury. It must be complete within itself, and it must plainly, fully, and distinctly set out the crime charged. In this case, we've got count 1, which charges Mr. Duke with malice murder. It reads that he did, with malice aforethought, cause the death of the victim by using his hand to kill the victim.
All right, I've got it. All right.
Great, thank you, Judge. It says, so that's count
Using
1.
his hand.
Using his hand to kill the victim.
Okay.
It doesn't say anything else. It says causes the death by using his hand. The felony murder count 2 is based on the underlying offense of aggravated assault. And in that one, it says cause the death while in the commission of a felony, aggravated assault, by using his hand. An object when used offensively against a person did result in serious bodily injury. The aggravated assault causing the death of the victim. Then we've also got count 4, which is the aggravated assault, the underlying aggravated assault.
And now count 3 is another felony murder count. What's the correct there? Burglary.
Burglary.
All right, thank you.
That one's based on burglary, Judge.
Count 4 is the aggravated assault.
Yes, and that one reads, unlawfully make an assault upon the person of the victim with his hand, an object which when used offensively against a person did result in serious bodily injury by using his hand to kill the victim.
All right.
So why is this invalid? There is no language to sufficiently describe the facts or the circumstances of this alleged crime. There's nothing. This fails to set forth any specific or particular acts or means by which he allegedly committed this crime. And again, this inquiry is not based on witnesses. This cannot be an evidentiary type hearing. You cannot consider anything outside of this indictment. This is a four corners type argument. It's impossible to determine based on this indictment what he's charged with doing. It's just impossible. It just says used his hand. It does not say how caused the death, nothing like that. The Georgia case law on this, but there's numerous case law on it. I'm going to start with Goodrum versus State, and that is a 2016 opinion. May I approach, Judge?
Please. You don't have to ask.
Thank you, Judge. Goodrum versus State reads that an assault occurs when someone attempts to violently injure another person or commits an act that places another in reasonable apprehension of immediate violent injury. An assault becomes aggravated if it's carried out with a deadly weapon or with an object, device, or instrument, which, when used offensively against a person, is likely to or actually does result in serious bodily injury. As we have held, the use of the hands to choke a victim can satisfy the deadly weapon or dangerous object element. Whether the use of the hands rises to this level is a question for the jury. However, in Goodrum, if you keep reading, it says the indictment charged him with committing aggravated assault, and how that indictment read is with his hands, an object which, when used offensively against a person, is likely. I'm so sorry. It's headnote 4. It's on page 3, the bottom left-hand column, the last paragraph. It starts with Goodrum also argues.
Okay.
In this case, they argued that choking was not enough. The court held that choking was enough. But the court specifically held that it was enough because in this case the indictment said, with his hands, an object which when used offensively against a person is likely to result in serious bodily injury by choking said person.
All right, the difference being by choking said person.
Yes, Judge. And every single case I'm going to cite, there's some other element that actually describes the offense to make it sufficient. In this case, in Goodrum, by choking said person. We do not have that in our case. So that is the Goodrum case. See, another case that we've got is Simpson versus State. And in that case,
Thank you.
yes, thank you. In that case, I'm looking at page 3 of the printout. In this one, they're talking about what makes an aggravated assault aggravated. What makes it a felony. And here they're talking about what can make it that is in the indictment if it says there's a weapon. How is the weapon used? For the battery? Something like that. In this case, there was a weapon used, and that's what made it an aggravated assault. Okay? So in this case, in this Simpson case, it was not a simple assault because they alleged in the indictment that there was a weapon, and they alleged how the weapon was used. They alleged the damage done from the weapon. We don't have that in this case. We don't have any allegation as to how there was an injury with the hand. With the hand, it says with the hand. In this case, in Simpson, there was a gun. And so they're talking about the gun is what was aggravating. Again,
Well, this indictment alleges in the aggravated assault count that the hand is an object that when used offensively against a person can result in serious bodily injury or did result in serious bodily injury by using his hand to kill. So it alleges the hand is a weapon,
yes,
but not how the hand was used that caused the injury.
exactly, Judge.
You believe it has to say by choking, by hitting something? Is that
Yes,
what you're saying?
yes, and I'll just go through several of the cases that highlight
All
this.
right, can you tell me again about Simpson now? How was this issue addressed in Simpson?
In Simpson, the question was the weapon. And it says that this was a jury charge issue, so this was not a demur issue, this was a jury charge issue.
Okay.
And the question was whether or not the jury was charged appropriately, because the indictment specified one way. And they said that it was error for the court to charge the jury that a crime could be committed 2 ways.
I've heard of
So, and that's what it was they were talking about here. But the reason that I brought this case forward is to show that in this case, they had the element of a gun in the indictment. And let me see, I'll just read you the language.
But that's not attack.
I'm sorry. No, it was not attached to the pretrial demurrer, no, Judge. It was not. But I have several other cases where it was.
Okay.
But in this case, the relevant portion of it is where it says the indictment did not, need not specify the manner in which he committed this simple assault because it was a lesser included. Instead, it has to include the aggravated assault and allege the aggravating aspect of the simple assault. So so that's why it's relevant here, because there is no aggravating aspect of the simple assault. What makes an assault with a hand a felony? What makes a simple assault with a hand a felony aggravated assault? Well, what they're saying here is did result.
Obviously, it would be the manner in which it is used,
Which is not described.
Is void.
Completely, Judge. And also, they tried to get a little bit more in count 4 where they said did result in serious bodily injury, but they don't allege what the bodily injury is. And I'll go into a couple other cases that say that they have to allege what. So if they're trying to get it to the felony level, not a simple assault, a felony aggravated assault, they're trying to allege what makes it a felony in count 4 by saying did result in serious bodily injury. But they're still missing what that serious bodily injury was. They're not stating that anywhere. And so it's deficient. Let's look at Wyatt because we're on that issue. So Wyatt, Wyatt is one where they talk about the level of the injury. And in that case, the indictment, the court said, was sufficient. They didn't know what the object was in that case. So it's fine if they don't know what the object is. But in this case, they knew that the injuries caused bleeding and damage to the victim's brain, rendering it useless. They didn't know what the object was. They knew it was an object, and they knew how it caused the death. So it was sufficient because they knew that an object was used, how it was used, how the death resulted from it. They weren't sure if it was what type of object. It was an injury to a child's head. They weren't sure what object hit the child's head, but they were able, in the indictment, and it says, the indictment properly identified the injury by alleging that the defendant caused bleeding and damage to the victim's brain, rendering it useless.
Well, how would the state do that in this case?
That's
Right. That's not your problem.
That's not our problem. I mean, and I have no idea. I don't think that they can, quite frankly. I don't know that they can. But that doesn't mean that
because of the absence of the body, which prevents the state from alleging these with more specificity. I would suspect I'm going to hear from them. I don't know, but there's no way to charge it according to your argument.
right. But that's the whole point. And I don't know if they can
I'm not
charge
being
or not.
critical of your
And I
argument.
understand.
You're fine. I'm just
Right.
okay.
I understand. I don't know if they can. And that doesn't affect his rights to an indictment that's perfect. His rights
You will notice this.
right. His right, Mr. Duke's right to an indictment that's perfect, his rights under the United States Constitution, under the Georgia Code, that require that we be put on notice as to what they're alleging. It doesn't protect him against double jeopardy. It doesn't allow us to adequately prepare a defense. It doesn't do any of the things that an indictment is required to do. Indictment isn't required to do a whole lot, but it is required to put us on notice of what we're supposed to defend against. This doesn't do that. And the fact that whether or not the state can do it or the state can't do it or any of that isn't relevant, quite frankly. What's relevant is what's on the page of the indictment. The state's proof that's not on the page of the indictment has no relevance whatsoever to this inquiry. They can get up here and they could argue things that don't have anything to do with this indictment. The argument has to be based just solely on this indictment. So in this case, in this Wyatt case, the count.
This was a aggravated assault case, felony murder as well of a child.
Yes, Judge.
Go ahead.
It was a felony murder based on aggravated assault and aggravated battery. It was a Supreme Court of Georgia case, 2014. And in that case, they charged.
This is anonymous? Okay.
Yes, and they charged, they charged the aggravated battery by depriving the victim of a member of her body, to wit, her brain, by striking her head against a hard object. And then they alleged that they seriously disfigured a part of her body, and then that they willfully, there were some other things based on the fact that it was a child in that case. But what the language in this case on page 4, it is under head note, let's see. It's,
Two.
it's
An
not all
indictment
the
that is
way.
not subject to general membership.
Where it starts with shortly after his indictment,
I mean,
about halfway down, it says that in this indictment, they put that by causing bleeding and damage to her brain. So we're again back to that by, how it caused death, how it caused the assault. That is what we're missing in our indictment. In our indictment under the aggravated assault, they say an object when used offensively did result in serious bodily injury. They're not saying how it resulted in bodily injury, how a hand caused serious bodily injury. And quite frankly, a hand can be a simple assault. So this could very well be a simple assault if you take the state's facts. What they've alleged in this indictment is not a felony aggravated assault. They just have not alleged that aggravating element that makes it an actual felony. There's a couple other cases. Walker versus State. Let me just pull that one out. In Walker versus State, that's another aggravated assault. And in that one, the indictment read, with an object, to wit, his hands, which when used offensively against another person is likely to result in serious bodily injury by striking victim repeatedly about her face with his hands. So in that case, there's that by language, that by. How the actual assault occurred by striking. We don't have that. So we've got case law here that says by choking. We've got cases that say by striking. We've got cases that say by causing bleeding. There's all this by. We don't have the by. We don't have that. Just one other case that I wanted to cite. Well, that's not true. There's a couple others. May versus State. In that case, and what I did was I tried to search for ones where they talked about the indictment and where they had this element, because there aren't any cases where they're lacking this element. My guess is because they've not had that, where it's lacking this element. I couldn't find it at least. But this case, May versus State, which is a 2007 case, in that case, the indictment said, did then and there assault the victim by hitting her in the face with his fist and knocking her down and stomping her on the head with his feet. Said hands and feet, instrumentalities when used offensively against a person, being likely to or actually resulting in serious bodily injury. So again, in that case, there's that by element. Right. Yes, Judge. The stomping. What action? What action was illegal?
this is 07.
Yes, Judge, and that's an 07 case. But, again, hitting her in the face with his fist and knocking her down. So in that case, we've got the by hitting her, knocking her down and stomping her. A couple other cases, Lizana versus State, which is a 2010 case. In that case, the indictment alleged that this was a death case, and they alleged that the cause of the death while in the commission of an aggravated assault by striking victim about the head and body, using his hands and feet as objects. The court in that case said it was sufficient because the use of the deadly weapon was by striking the victim about the head and body. And in this case, they talk about how striking is enough, beating is enough, choking is enough, or strangling is enough. They specifically use this. How those are. But again, we don't have that many of those. And that's a 2010 case, that's a murder case, so it's a Supreme Court case. Justice Carly. I also want to cite, I don't know how to pronounce it, Howland versus State. That's 2002. This is an appellate case, not Supreme Court, but it's just aggravated assault they were considering in this case. And it basically said under the aggravated assault statute, a jury may find hands and feet under certain circumstances to be deadly weapons, but it depends on the use, the wounds inflicted, and other surrounding circumstances. So we don't have, in this case, any of those alleged in the indictment. Well, obviously the state doesn't have to prove their entire case in an indictment, or doesn't have to put their entire case in an indictment. They've got to put enough in to protect against double jeopardy issues. They've got to put enough in to protect our ability to adequately prepare. We have no idea how they're alleging that he used his hands to commit this assault that caused the death. How did this happen? How did the hand cause a death? How did the hand become an aggravated felony assault? There's one more.
The use of the hand.
How did the use of the hand?
Right.
Yes.
That's what you're saying today.
Yes.
Is an indictment charged that the defendant used a tire to cause the death? You would have to say how the tire was used.
By striking the victim
Hit
with.
him in the head, hit him in the leg, cause him bleeding, whatever.
Yes, Judge. Yes. By
No
striking.
matter what the object is, just how it's used.
Yes, Judge. And most of the time, the use of the hands is by strangulation. So most of the cases are choking deaths with the hands. Sometimes the cases with a hand are a beating, and then there's some indications how that differed from a simple assault, how that became a felony, how it was used offensively to elevate it to a felony level.
So if it's a hand, you need to allege it was used to choke the victim, it was used to strike the victim, something.
Yes, Judge. Something.
Okay, thank you.
Thank you.
Who's up on this, Ms. Hart?
And I'll be citing some of the same cases that the defense counsel cited. Did you have copies of those already? Just the first thing that I would point out to the court is specifically under the rules of the state of Georgia, special demurrers, which is what this is, are required to be filed 10 days after the indictment, or excuse me, 10 days after the arraignment occurs. In this particular case, Judge, the defendant was arraigned on May 4th of 2017. This particular special demurrer, which was filed by prior defense counsel, was not filed until August 15th of 2018, which would be over more than a year later. I would point the court to several cases which have indicated that the fact that it was not filed within 10 days after the arraignment means that it cannot be considered, specifically Coleman V State, Judge, which is 318 Georgia Act 478. So just at the outset, Judge, I would argue that the court should not consider the demurrer based on the fact that it was not timely filed. A general demurrer was filed in this case as part of the original packet that was filed, omnibus motion that was filed by defense counsel in the case of Hope Defenders. But a special, it was filed the same day. The general demurrer was filed. It was specifically
Same day of the arraignment?
Yes, sir.
I'm sorry.
And it was specifically titled a general demurrer. I went back and checked just to be clear that there was nothing that maintained the right to file the special demurrer, and I could not find anything in the record doing so. Judge, another case, sorry.
Go ahead. We still on the same issue?
Yes, I was going to say, I just have one more case citing to that. It's State versus Wilson, which is 318 Georgia Act 88. And I approach. Again, same situation, failure to file it within 10 days results in the fact that it cannot be considered a challenge. I will let the court know, I'm aware that usually the court does not necessarily want to tie people in to make them comply with some of these because of fairness issues. This is not a situation where discovery would have been required, and we're not talking about a delay of a month or even 6 months. It was over a year later before special demurrer was filed.
This was filed in connection with the court's, I guess, the first order I issued for
Yes,
all
sir.
motions, all.
Yes, sir.
All right, I'm going to look a little that.
Thank you, Judge.
All right, go ahead.
Looking at all the cases that defense counsel cited in this case, Ms. Merchant, not one of those cases that were cited actually addressed the issue at point. Looking at the Goodrum case, the issue before the court was whether or not choking was a manner by which you could charge aggravated assault. The Goodrum case was decided after the statute changed and specifically incorporated. Yes, sir. The aggravated assault statute changed and specifically incorporated strangulation into the statute. And so Goodrum was decided after that, and the allegation in Goodrum was that because the original aggravated assault statute did not include the strangulation language, which is there now, that prior to that indictment, prior to the change in that statute, choking and strangulation was not a method by which aggravated assault could have been had. that case is not on point, and that's what Goodrum actually stands for. In Wyatt, which was a case that she cited, Wyatt actually deals with the battery. Let me skip Wyatt, so I'll come back to that. Walker and May both deal with the fact that they did not allege the language of deadly weapon. In those particular cases, the argument that was being had, no one challenged whether or not they had said the way in which the items were used as deadly weapons. They said that they did not include the language of deadly weapon. Instead, they included the language of an object which, when used offensively against another, is likely to or actually does result in bodily injury. And that is what the argument was. In those cases, the court held that because the language of is likely to or does result in serious bodily injury was in there, that was sufficient. You didn't have to have a deadly weapon. And again, all of the cases cited, that's the ones I'm going to go through. None of those cases actually look at the issue that's before the court today. I would also disagree with defense counsel that there are no cases on point as to this issue. I actually do have some of those, Judge. The first I would point you to is Johnson v. State, 286 Georgia 432. It's a 2010 case. In this particular case, the language of the statute charged that the defendant did unlawfully assault the person of the victim with objects to wit, hands and an object, the description of which being unknown, which when used offensively against the person is likely to and does result in serious bodily injury. First thing I'll point out.
This is aggravated assault case?
Yes, sir.
Felony murder.
It's an aggravated assault case, Judge. And felony murder. I believe all of the ones I'm going to cite before are aggravated assault and felony murder.
That's what I was saying.
So, Judge, in this particular case, the defendant argued that the elements of the offense were not sufficient. They were not sufficiently definite to advise him of what he was prepared to confront, and therefore it was void. The court held that language, there's nothing in there as to how the hands or the other object were used, but that language specifically tracks the language of the statute, and that this case, and then also several of the cases cited by defense counsel, specifically Stinson, say that in charging an aggravated assault, the state is not required to charge the elements of the simple assault which create the aggravated assault. The only thing that we're required to charge is the language resulting in what was used and the fact that it was in some way aggravated. And the way that is to be charged in each of these cases is to either allege that it was a deadly weapon, or that it was a weapon that it was an object which, when used offensively against a person, is likely to or actually does result in serious bodily injury. Specifically looking at that case in Johnson, that was the exact issue. The issue we're looking at today was the exact issue that they addressed in Johnson, and there they held that it was sufficient to put him on notice and that there was no reason. Now, in this case, they were arguing ineffective assistance of counsel, I will point out to the court, but they held that it was not ineffective for failure to object because this indictment was sufficient.
All right, to with hands and an object, the description of which being unknown.
In that
When
indictment,
used offensively against a person is likely and does result in.
that indictment was even, I would argue, more vague than ours, because you have that extra element of an unknown object, and ours we've said it.
And why put that in there, kind of what I was saying, but anyway.
I would assume it's a situation where they did not have the ability to charge the exact cause of death based on something to do with the body.
All right, because the indictment used the language, including the essential element, it was sufficiently definite to advise Johnson what he must do. Okay. All right, Johnson, you got it. What you got?
Judge, there's also, I'll point you to Belcher v. State, Belcher v. State. It's another 2010 case. This case dealt with a knife, not hands. However, it looks at the same issue, whether or not we're required to charge the simple assault. In this case, the language said that he did make an assault upon the person of the 5-year-old boy and his mother with a knife, a deadly weapon.
Where are you looking?
Sorry, it is under issue 1.
Belcher, or-
If you look on page 3 of 5, Judge, it will be on the second column, the third paragraph down. We discern.
Okay.
The language was that did make an assault upon the person of the 5-year-old boy and his mother with a knife, a deadly weapon. It specifically again said that it tracked the language of the indictment and goes.
Track language of the statute.
Excuse me, language of the statute. And the fact that the knife was alleged to be a deadly weapon was sufficient.
Okay. So there's no by.
There's no manner in which it was used. Looking at specifically the Stinson case, which was cited by defense counsel, that was a case in which a gun was used, Judge. But there is language in Stinson that, even though they weren't addressing this specific issue, there is language in Stinson that addresses this. I'll also let the court know in Stinson there was an issue. I can give you another copy of Stinson, then, Judge. May I approach? This is one of the ones that was cited to by defense counsel.
Simpson.
Oh, Simpson.
Simpson or Stinson?
Sorry, this is Simpson. Okay, I apologize. I thought.
Simpson, then. I'm sorry. I thought you said
Okay, no, I meant Simpson. I apologize. I misheard her earlier.
Okay. All right.
So let me give you Stinson. Wait, sorry. I think I gave you the wrong one. I've got myself confused now.
All right.
In that case, Judge, I'm going to come back to Stinson. I apologize. I thought that was what she was addressing. Okay. Moving on to some of the other cases that deal with this specific issue. Wallace V State, which is again an aggravated assault case. In that particular case, they looked at, it was a handgun that was used.
Thank you. Wallace. All right.
If you will look on page 3 of 4, Judge, about halfway through that first paragraph.
All right, the general rule.
Yes, sir.
What's the paragraph?
Yes, sir. It says the instant indictment tracked the language of OCGA 16521 in alleging that Wallace made an assault upon the person of Joe Jones with a handgun, a deadly weapon. This language is not too vague to inform the accused of the charges against him. Again, there is no manner in which the handgun is used alleged there. It just simply says that it was a dangerous weapon. In our case, we have satisfied that by indicating that this was an object.
You don't have to allege, according to this case, where you shoot him with the gun, beat him with the gun,
Correct.
that you used.
That you used a gun, correct.
Okay.
And again, the prior cases I quoted to the court say the same thing. And some of the language in there, again, continues to talk about the fact that what you're talking about is the fact that we don't have to allege the underlying simple assault. As it relates to the felony murder, Judge, the cases that we have, that I've already cited, that dealt with felony murder, say the same thing. That as it relates to the felony murder, we're not required to allege the details of the aggravated assault. We're simply required to allege the underlying offense, that being an aggravated assault, and that it was a felony. And so that would be sufficient. I would point out, Judge.
Your position is the same thing applies to the Malice murder.
Correct, yes, sir.
All you got to do is say they used what they used,
Correct.
not necessarily how.
And that it resulted in her death, yes, sir. As long as the language is tracked and we've indicated the item that was used. I would point out the Wyatt case, Judge, which was quoted by defense counsel. Some of the language that was quoted talking about the fact that of the serious injury being actually specified. In that case, when it talked about the aggravated assault count, it was not in fact specified. Wallace was a case where they indicted it and then filed a re-indictment. That involved a young child who, the allegations, they thought the child's head had been hit up against a hard object. The defendant in the case gave a statement alleging that the child hit its own head against the toilet. And so that was how the injuries had occurred. In that case, they re-indicted it, but the language quoted by the defense counsel actually related to the aggravated battery count. Because if you look at Wyatt, as it relates to the aggravated assault count, they did not allege the manner in which it was.
Is that challenged in Wyatt?
Yes, sir. The entire indictment was challenged in Wyatt. And Wyatt specifically, the allegation on the aggravated assault, count 5 of that indictment alleged to be unlawfully made assault upon Andrea with an object, the exact nature of which, I'm sorry, page 6 of 10. And it's the second column right under aggravated assault.
Second column, what's that? Based on the indictment? That
Yes, sir. No, sir. In other words, it says aggravated assault.
I see aggravated battery.
Are you on page 6 of 10?
I'm on page 6.
Are you looking at her copy of it? That might be the problem.
I'm looking at state versus Wyatt.
Okay, I think you're looking, I have a different printout. Judge, mine would be the aggravated assault.
Was the subheading go under aggravated assault?
Yes, sir.
Now
It would be prior to that.
I see the aggravated assault.
Okay. There, the language was that he unlawfully made an assault upon the victim with an object, the nature of which is unknown to the members of the grand jury, which when used offensively against another person is likely to result in serious bodily injury.
Wyatt argues the lack of detail about that dangerous
Yes.
leaves him without adequate notice. The state argues in response, the indictment is as specific as it can be because of the head wounds
Yes, sir.
and the surgery performed in the attempt to save her life. We conclude no basis under our precedent that grant a special murder on those cases.
And then if you look the next paragraph under that, Judge, it specifically talks about, again, that we are not required to allege the simple assault, which would be the manner. We're simply required to allege what makes it aggravated, and that would be the fact that the hand, in this case, was used offensively and caused the serious bodily injury. That is the aggravating acts that we're required to allege.
Only that, let's see, an indictment for aggravated assault should allege the aggravating aspect of the simple assault. What does that mean?
It specifically relates to the fact that either whether it's a gun or a hand or a knife, that it was either a dangerous weapon or that it was an object which when used offensively against a person is likely to result in or does result in serious bodily injury. That is the aggravating aspect, that does have to be alleged.
Not the factual aggravating aspect.
Correct.
That's what you-
Yes, sir. And again, the cases that I cited to you would all address that same issue.
Thank you, Ms. Lawyer. Anything further?
No, sir.
All right. Ms. Purchase, you get the last statement.
Thank you, Judge.
All right. Johnson, Belcher, and Wallace are what she's brought up. You had a chance to peruse this?
I have somewhat, but there is an overwhelming issue with all of this. In all of the cases that the state is presenting, there is a weapon used. There was a knife. There was a gun. You cannot have a simple assault when you assault someone with a gun. So the gun in and of itself is enough to take something from a simple assault to an aggravated assault. A knife over 3 inches is enough, if alleged in an indictment, to take something from a simple assault to an aggravated assault. A hand is not. You can have a hand in a simple assault. It is the manner in which the hand is used. That is why the case law requires the allegation of strangulation. Or if it says fists, how the fists were used. To beat them, to, something like that. This is different. There is no weapon that automatically makes this a felony. We have hands. Hands are simple assault. Hands can be aggravated battery. Hands can be any of these things. Guns cannot. Guns cannot be misdemeanors. Guns are automatically an aggravating factor. So in these cases, we've got, first of all, and again, in our indictment, it does not say how the hands are used. It has to say.
Johnson is a hands case, right?
Yes, and Johnson, okay, so let me.
Johnson objects that hands in an unknown object when you finish it, doesn't put him on notice what he's got.
So if you look at Johnson, Johnson, first of all, is a plea. It's an out-of-time plea to where they went to trial, something happened, and then he entered a guilty plea.
For an out-of-time appeal.
An out-of-time appeal, yes, sir, sorry. So he is asking for an out-of-time appeal, and he's only challenging count 3. in this case. The murder case, if you look at the top of page 3, the murder case included the strangulation death of the mother. So it included how the hands were used, by strangulation. The count he is arguing about is not the murder count. He is only arguing count 3, which is the aggravated assault count.
Okay.
And in this case, he didn't challenge the murder count. He challenged this aggravated assault. And the court said that he was not entitled to an out-of-time appeal. They believed that the indictment used the language, including essential elements, and was sufficiently definite to advise Johnson of what he must be prepared to confront. Yes, because it alleged in another count strangulation. So the indictment, read as a whole, put him on notice because the murder was strangulation. So yes, he was on notice because it's strangulation. This supports our contention that it should include somewhere in the indictment how the hands were used to cause a death. Johnson included that.
I think this was a plea.
It was a plea, yes, Judge. It was a guilty plea.
Then it talks to.
Well, I think it was a guilty plea. You know what? Either way, it doesn't matter.
It was his jury trial. Talked about jury trial again on October 17, 2016. But then he must have talked about when he entered a guilty plea during the trial.
During the trial.
Yeah.
Yes, during a recess, he agreed to plead guilty. Either way, whether it was a plea or a trial, either way, it includes the indictment in this case, the murder counts include the strangulation. So the fact that the court held that count 3, the aggravated assault, was enough doesn't really matter because it's the same, it's got an element we don't have here. The next case that the state cited, I think, is Wallace. Wallace is a gun. A gun's enough. Wallace is a gun. A gun automatically is aggravated. And in this case, it's specifically the indictment on the copy that the state gave us, page 3 or 4. It says, Wallace made an assault upon the person of Joe Jones with a handgun, a deadly weapon. Yes, a handgun is enough. The next case they cited, Belcher. I'm not completely certain why Belcher was cited. I know it includes a knife, but in Belcher there was a negotiated plea to an armed robbery and a kidnapping. One of the things that they argued, so it's a plea again. They're asking to withdraw the plea. Again, it's an out-of-time appeal. I believe on page 647, page 3 of 5, it says that Belcher is arguing that the indictment was fatal because it doesn't specify the aggravated assault. Even more Belcher correct, he ignores the fact that he did not plead guilty to the aggravated assault. So the issue is moot. However, they did look at it and found no defect because it says it was an assault with a knife, a deadly weapon. They held at the bottom of that paragraph with a certain knife, same being a deadly weapon, and another victim with a certain paring knife, same being a deadly weapon. Again, a knife is a different issue. Any knife over 3 inches is automatically a felony.
Let me see. What this is about. I'm using his hand.
And Belcher's not a murder case also.
Right. It alleges the hand is an object when used offensively did result in a serious bodily injury. Now, you're right. Wallace and Belcher are deadly weapon, which is a separate way to charge aggravated assault. And you believe that to be the difference?
Yes, Judge. That is the difference. And that's sort of what I was arguing at the beginning. There's got to be something that makes it a felony. Because a hand can be a simple assault. Now, a hand by strangulation, I know the state talked about Wyatt. Wyatt did go into talking about how strangulation is different. I'm sorry, Goodrum, how strangulation is different. But it doesn't matter because even though the statute was changed to include strangulation, the case law has always said strangulation was enough, that strangulation is a felony. I mean, that's always been the law in Georgia. Strangulation or choking with a hand is used offensively and it becomes a deadly weapon. A hand can become a deadly weapon when used offensively, but the state has to say how it's used offensively because a hand in and of itself is not a deadly weapon.
As opposed to a knife and a...
Yes, Judge. Yes. You cannot have a simple assault with a gun. And Wyatt, I know the state cited, we cited it and the state argued it again. And in that case, the state was arguing on page 5 of the copy that I gave you. The state is arguing this language about the simple assault versus the aggravated assault, and that they didn't know what the object was. But again, the indictment taken as a whole in this case gave him notice of what he was supposed to defend against, gave him notice of how this object was used offensively, because the object may not have in and of itself been a crime, but they alleged the manner it was used, alleged the injuries in that case. There was a lot alleged, and so taken as a whole, that indictment provided a lot more.
I'm not following. All I see about from Wyatt is the alleged deadly weapon.
Count 2 charged felony murder based on aggravated assault. It added that the assault caused bleeding to and damage to the victim's brain.
Okay.
That was enough. We don't have that here. They didn't know the exact nature of the object, but they knew how the object killed her, and they put that in the indictment.
Okay. All right, anything further on this one?
No, thank you, Judge.
Thank you. Let's take about a 10-minute recess.